Commissioner, Deputy Commissioner, thank you for appearing at committee, and thank you for your responsiveness on a couple of issues that I personally reached out to your office on, including this one. I just want to, we had a little bit of confusion around the timeline when we had CRA officials here. So if I understand you correctly, can you just confirm when were you made aware of the breach, the number of breaches dating back to 2020? Was that May 9th? Is that correct?
That's when we received the formal notification of those breaches. And the policy, the Treasury Board policy, requires that a notification be given to my office formally within 7 days of the organization being made aware of it. In this case, clearly this didn't happen because some of those incidents dated back to 2020.
And so after there was obviously a large time delay between, and CRA officials had acknowledged that they were aware of these breaches, and in fact, testimony suggests that for many of these breaches, the minister is made aware of these breaches, that they were not reported in a timely fashion. Even after that, did I hear you right? In October, they've petitioned the Treasury Board to actually not report breaches on the 7-day period. They actually want more time on a quarterly basis?
For some of them, they've identified that this was operationally challenging for them to do that. They've requested this exception, and as indicated, I was prepared to support it with some conditions. The 3 month, 7 day may not make as big a difference, but the 7 day, 3 years that we're talking about in this instance, that's the major concern. And again, if for specific operational reasons for a specific amount of time, that's a different question. But the concern that we see, and we saw it, in fact, even in this earlier investigation of the GC key that we reported on in February, even then we had some concerns about being notified in time, getting responses in time. So it's a concern, not just for CRA, and that's why it should be a legal obligation.
That's very good advice. Do you think that there's an accountability issue within the department about who maybe owns the reporting and accountability requirements within CRA? I'm just trying to understand how, on one hand, a department would acknowledge, yes, we knew that these things were happening in real time, but failed to properly notify or follow the rules that had been set out.
Right. Well, I mean, I think what we hear is that there's a focus from the departments to notify the individuals, and that's a good thing. That's important, and you need to contain the breach. I don't know the reasons why we're not notified formally within the deadline, but what I know is that it's a concern. If we're not notified in time, we can't provide advice and guidance in time, and that elevates the risk for Canadians. And so I also know that if something is required by law, there's a greater likelihood that it's going to be complied with than it's required merely in policy or directive.
And as part of your investigation, will you be looking at the activities that gave rise to the breach? We've heard some conflicting reports about whether it's a third party, whether it may have been on the departmental side. Is that something you'll be exploring?
Well, we want to understand what happened. We want to understand whether the measures were sufficient. So we need to have the context. If there are some third parties that are involved in this situation, then we're going to look at that. If it raises questions under private sector or public sector privacy law, then we'll address that and see whether we need to amend the scope of the complaint. But our position is that the government, if the government is contracting with third parties from the private sector, the government has an obligation to make sure that its third party partners are providing adequate protection.
Right. And what obligation would, say, the department have to notify the public generally about potential breaches or risks to their own, if it's from one particular third party or some kind of similar instances? In this case, the public was not notified at all. I acknowledge that some individuals were contacted, but the general public was not made aware either.
Right. Right. Well, and there's really the three categories, right? You notify the individuals because you need to protect them. You need to make sure that they can protect themselves. You need to notify the regulator, my office. You need to notify Treasury Board and others. But the question of notifying the public then becomes a question of trust. How do you make sure that the public isn't learning of this from the media? that the individuals may also be learning of this from the media. And in fact, I think this was discussed in earlier testimony. There's also a taxpayer's ombudsperson. There's also a taxpayer's charter. And one of the principles in there is also that taxpayers be notified promptly if there's fraud schemes and so on. Again, for the reasons that this is just important for trust, and it's important to manage the stress level of individuals.
And do you feel empowered? Does your office have the right authorities to make recommendations on internal processes, accountabilities, but also, I recognize this Treasury Board exemption. I'll call it an exemption. But if you've just gone through a very difficult period where you've not reported, I find it a bit hard to imagine that the answer to that is giving the entity more time to report. You'd think it'd actually be the other way around. No, you're on remedial actions and you need to report more frequently. I think that would make a little bit of sense.
Right. Although I think there's something to be said about acknowledging a challenge meeting and meeting a requirement and explaining why and seeking an exception, I think is better than breaching it and not doing anything and not saying anything about it. So I think that's an important element. But to your question, yes, our investigation will look at that. We'll make some recommendations, as we did in the earlier investigation. And our earlier recommendation included improvements on communication, accountability. We had found in that earlier case that there was departments pointing fingers at each other and saying, it's not us, it's this department, it's that department. And we found that that was an issue and had to be corrected.
Thank you. Commissioner, just wanted to follow up on actually my colleague, Mr. Housefather, made what I thought was a reasonable recommendation with respect to comparing what happens in the United States, in particular with their tax service, the IRS, and the close coordination that they have with industry on identifying, communicating, trying to plug the holes or plug the holes in the dike, if you will. And shutting down some of these, what I'll call account takeovers or whatever, privacy breaches in general. That same kind of coordination doesn't seem to exist here. Do you think that would be in your remit to make some recommendations to government to explore the opportunities they have to work with third parties to address these issues?
I think so, and we've done recommendations in the past in terms of the public sector use of private sector service providers and what are some of the parameters. What you're referring to is coordination, participation, partnership with those and perhaps with other organizations. And I think it's absolutely within my remit in making recommendations to say these are some of the best practices we want to see.
And would it be fair, just to help me understand, if the privacy breach that occurred with respect to these 31,000 cases, if that was a result of an individual company's policies, and they were aware of that company would have an obligation to report that breach to you, correct?
Private sector organizations do have an obligation
Right.
to report breaches to us.
And so just on that point, has any private sector organization made a report to you about this in particular breach?
I'll look
About
to
this?
about this
About the
private
breach at
sector.
CRA?
No.
Okay. So when the CRA says it's a third party and the company in question says we're not aware of it, and the company in question would have an obligation to report these privacy breaches, it would make sense to believe that it could be some other nefarious third party who had access to this information. Is that correct?
Well, I don't want to speculate because we're going to be investigating all of those things. And so this will be our opportunity to get to the bottom of it.
Fair enough, and we look forward to your recommendations. Do you think that we should, or do you think maybe this committee should make recommendations, or the CRA should consider changes to its performance pay and compensation structure with respect to privacy, given how great of a concern of importance it is for Canadians?
Well, I think that every tool that can improve privacy compliance is a good one. Performance management tools are good tools because they focus the minds of executives, so I would be supportive of that. Yes.
Okay, thank you. In this general scope of privacy, something I've written to your office about before, perhaps a slightly different question, but I feel it's on topic, and I haven't had a chance to speak with you. Do you think it's in the public interest both for members of parliament as legislatures, but also for the public to have a full understanding of how many individuals received the private, personal, confidential details of those individuals who had their bank accounts frozen as part of the Emergencies Act invocation?
So you're asking if it's in the public interest
To find out how far and wide that information went.
Right. Well, I think that there's situations perhaps where timing would preclude that because you want the organization to safeguard the information. So there's situations where you're going to wait a little bit before making something
Of
public.
course,
but ultimately, as a lessons learned, I think it's something that...
That's good. And why I'm getting at this is because the government claims that it had sent these very private details, including previous convictions, license plate numbers, to 50 individuals, however, 50 organizations. However, a couple of those organizations, in particular the Securities Commission of Ontario, the Mutual Fund Dealers Association, then went on and sent that information to upwards of thousands of individuals, but we actually don't even know how far and wide that information went. So just trying to understand, for me, it would make sense that we know the processes that led and how far and wide, and I just wanted your opinion on whether you think the public has a right to know and whether Parliament has a right to know.
I think it's important to know how far does the breach go. So how widely was this information shared? Was it appropriately done? Were there some valid reasons? Was there some valid contractual or other protections? And so those are the things that we're going to be looking at in our investigation.